Welcome to the Children First Family Law podcast. And I'm so glad today to have as our guest Cynthia Roberts, who has a wealth of experience working in high conflict, divorced landscape, families, children. She has an entity called Roberts Family Resolution. Is that right?
Yeah, Roberts Family Resolution Services.
Great. And that's here in Colorado, but she's got a lot to share with us about her experiences working in this arena and sort of how we can, from the lens that she's on, with doing supervised parenting, work as parent coaching, what else? Child and family investigation, therapeutic work, just sort of what she's seeing from her vantage point in all of this. So welcome. I'm going to just turn it over to you to sort of give us a little bit of your background and how you got into this.
Okay, yeah, great. My name is Cynthia Roberts, and I am the owner of Roberts Family Resolution Services. I am a registered psychotherapist, child family investigator, parent coordinating decision maker, therapeutic parent coach, therapeutic supervised visitation specialist, and I have a team of staff that do supervised visitations and parent coaching in Colorado. My background and training is at the cross section of mental health and family law. And in all of my roles, I have to ensure that children are emotionally and physically safe and that the well being of children is at the forefront of everything that I do. So I got into this field because I was interested in psychology, and I originally started working with mental health patients, specifically in outpatient and inpatient programs, with adults and then children as well. From there, I got into supervised visitations, case working, and kind of the cross section with child welfare and social services. And I further went through my education in fields of child abuse, sexual abuse, domestic violence, coercive control, really understanding mental health disorders and how they impact high conflict parenting. And then I kind of went down the path as well of family law, getting into roles of a PCDM and a CFI, which both of them essentially look at parenting time and decision-making areas in regards to family law. Every family is different and every case is different. The court using supervised visitations, they can use it for different reasons. So they can use it in a way to assess what is going on in a case before they hear the facts from both parents, or they can use supervised visitations as a way to better understand the case and to understand what's going on with the kids. In all of my cases, I have not had any judge look at supervised visitations as a long-term option,
You're
which I feel is sometimes helpful and sometimes not helpful. I think that abruptly ending visitations is dangerous for children. The best recommendations that I have for attorneys and judges when they are ordering visitations is a few things. First of all, it's important to be very specific in the court order about supervised visitations. You are dealing with two high conflict people who may not be able to choose a supervisor, choose a schedule, and they both may want to add different rules and things like that to the visitation. So what ends up happening is these kids go a longer time without seeing their parents, and it creates more conflict and more litigation problems. So, what I recommend to include in the court order, instead of being specific and saying visits shall be Monday, Tuesdays, Wednesdays from 5 to 8 p.m., every other Saturday from 10 to 12, or once a week for 4 hours and twice a week, instead of putting it like that to allow less conflict with the families, the order should state a minimum and maximum amount of number for supervised visitations. And it should be considered, with the child's threshold and also with the dynamics of the case.
Mhm.
Allowing more time will not endanger the children if the supervisor is there and doing their role to make sure that everything's documented. So sometimes I have non-visiting parents tell me, I only want to allow 30 minutes, once a week because I don't want my child to be exposed to them long term.
Mhm.
And I'm like, well, when visits end, they're going to be with them for a whole week or a whole
Right.
weekend. So
Right.
having more or less time, you know, don't limit parents' parenting time. I definitely think there needs to be like a set thing that they can't be every single day or something like that. But allowing like a maximum of 8 to 10 hours a week is appropriate. And in the court order, what I would recommend to put would be visitations shall be a minimum of 2 hours, a maximum of 8 to 12 hours, and the parties shall work with the supervisor for the supervisor's availability. If either party does not work with the supervisor's availability, they will be held in contempt.
Right.
And what that does is that allows it to be more rigid that, hey, if they contact a supervisor, the supervisor may not be available for that specific court order. So that's the most important thing. Set a minimum and a maximum. And instead of looking at a from a perspective that supervised visitations need to be restrictive in its entirety, look at it that a supervisor is there to make sure that the parenting time is safe and meaningful and to not restrict the time that they have. I started my CFI work because a mentor told me, "Cynthia, you need to do this. You'll be great at it."
Right.
So when I first got started with it, I did my first case and we're dealing with parents' problems as they constantly come in. And it's a very important role. I've enjoyed and I still enjoy all of the cases that I take because my recommendations have protected a lot of children. They've also helped with a lot of complex family dynamics. And I receive positive feedback that I'm extremely thorough in my reports. So I'm glad to be an assistance to families. But overall, there seems to be, a lot of kind of internal obstacles with CFIs, such as CFI complaints and the
You mean complaints people make about them, some
yeah,
of which are warranted and necessary,
yeah.
but some of which are frivolous and just because they don't like the report.
Yeah, so that happens a lot to my colleagues is somebody just doesn't like a report, they're dealing with a high conflict individual. We're also sometimes dealing with dangerous individuals as well. So I've had my fair share of threats and it gets to a point where sometimes you don't feel safe, you know, working with these families and you don't have support. I would say the biggest obstacle as a CFI, the reason why so many CFIs are leaving the field is because we don't have legal counsel to represent us throughout the process when we're dealing with high conflict families. And that is, I think that um, the court, attorneys, professionals and parents need to be prepared that there is and will be a CFI shortage, and we have to think about ways to move around it. I think the best way to move around the shortage instead of maybe going to PREs, which are great, is to go to CLRs because CLRs, I think, are the new CFIs. A
Yeah.
CL is great because what you guys do is kinda similar to what a CFI does in my perspective, but it's more efficient and it's more in the child's best interest. Our visitation guideline rules are that the parent cannot talk about court or legal issues, finances, or the other parent. And so our role isn't there just to let anything and everything happen and, put these kids through everything. We make sure we check in with them before, during, and after the visitation, and we
With
don't
with sorry, with the kids?
yes.
Okay. And how does
Yes.
it work? Like, I know often the parents are in such conflict, they can't even do an exchange, right? So I know I've been to somewhere the parents have exchanged at a shop or a coffee shop or whatever, or the park. and there's a time where the parents they're not together. One parent's dropping off with your people shortly after the other one shows up, and you're able to the kid then, right? Is that pretty common?
Yeah, so I develop no contact during exchanges. This way, our supervisor can debrief with the children before and after the visitation without either parent present. This allows time for the children to disclose statements to the supervisor, and it also helps build rapport because the supervisor isn't as actively involved the entire visitation. It gives the child time to know that they have a safe place to talk with the supervisor.